I'm Chris Beal. I'm with the law firm Levine, Sullivan, Koch & Schultz. I work out of New York and Denver as well as here. I'm a copyright, trademark, libel lawyer, a jack of all trades. Because I do both IP and First Amendment work, I get to be on both sides of the ownership issue. I get to say, we own it, you can't use it, and I don't care that you own it, we get to use it. That dichotomy between ownership and use, also known as fair use, and whether or not your use is fair, is one of the central things we're going to talk about today. I have another life where I'm a teacher in a law school, and I inflict on my students professorial interrogation, where I actually make them answer questions as opposed to me answering their questions. I will resist the temptation to do that with you, but fair warning, I might call on you to answer a question or so. The point of today's talk is to give you a beginner's introduction to copyright law so that you can appreciate that there might be a problem and that you should raise your hand and you should say, I think there might be a problem, we should talk to somebody, whether it's Albert or Ken or anyone. The rules of the game are you're not allowed to call me until Albert says you can call me, because my meter starts running at the drop of a hat. That's not true. I'm happy to take phone calls, and I work it out what we do around the costs. How many of you all know where the copyright rights come from? How did we start with copyright law? When was the first copyright statute? Anybody want to hazard a guess?
Everyone's quickly Googling.
Everyone's getting their BlackBerry out or something and Googling it. The very first Congress in 1791 passed the very first Copyright Act because it's in the Constitution. It is one of the few things that Congress is explicitly instructed to do. In the Constitution, the framers of the Constitution directed that among the powers, supposedly limited powers of Congress, is the power to promote the arts and sciences by securing to authors and inventors for limited times. One wonders now, because the term of copyright is the life of the author plus 70 years, for limited times, the benefits in their creation. That's what the Constitution says Congress is empowered to do, and when Congress first came together in 1791, they passed the first copyright statute. We've had many copyright statutes since then, and amendments to it. The current statute that we operate under is called the 1976 Act, to be distinguished from the 1909 Act, which actually went into force in 1978, just to be confusing. Everything I'm going to talk about, copyright lawyers sometimes like to talk about the differences between the 09 Act and the 76 Act, and it has actually has a lot of effect on musicians, because prior to the 1976 Act there were very different protections for musical performance. That's not where you guys live. In fact, you guys live today in an internet age that the Copyright Act really, the 76 Act didn't anticipate. There was effort, and there's been effort along the way to anticipate some of the nuances created because of the internet. But for the most part, we live in a world, at least copyright lives in a world that was pre-internet. That has important significance, but it doesn't change the legal ramifications. The first thing that we should all, as an sort of baseline understanding, get to is who owns this stuff? Has anybody started? He started taking notes. I love it when people take notes. Does he own the copyright in the thing he is writing down on his pad? Yes. Tell me, Are you here as part of your employment?
I am.
Are you taking notes as part of the scope of your employment?
I am.
You don't own the copyright in what you just wrote down. Ownership of copyright starts with the person who writes the thing down, who fixes the expression in a tangible medium. Writing it on paper is a tangible medium. Typing it down is a tangible medium. All that you have to do to acquire copyright is to fix the expression in some way, in some fixation, even for a moment. The recording that we're doing on the videotape, even though I'm speaking extemporaneously, fixes my expression, so voila, I now have copyright. Or, question, do I? Because I'm here as a result of, I'm an outside attorney, but I'm here at the behest and hopefully payment of Freedom Communications.
We'll discuss that.
Yeah, we're going to talk about that later. Actually, payment is not necessary for ownership. But it does start with fixation. Once the expression is fixed, the author is either the person who created the work or the person who commissioned the work if it is a work for hire. Work for hire is actually where most of you all who are content producers live, because work for hire is either content created by an employee within the scope of their employment, or content created pursuant to a written agreement. A written agreement that has the magic words, work made for hire. So, suppose you have a stringer, and the stringer is going out to cover the high school football game. And the stringer comes back with the story, and you assigned the stringer to go write the story for Friday night's game at the high school. And the stringer comes back and gives you the story, and you do some editing to it, and you publish the story. Orange County Register publishes the story. Does Orange County Register own the copyright in that story about the high school football game that's in the newspaper? No. Not unless you have a written agreement that says work made for hire. Even though you hired the guy, even though he did it for you, even though you edited it, even though you published it, you don't, Freedom does not own the copyright unless there is a written agreement. This also applies to not just words written down, photographs, video, content created by someone who is not an employee. What does it mean to be an employee versus an independent contractor? Albert can tell you all about that. The short version is, the easy version is, if the person is not on your regular payroll, if the person is not getting a W-2, if the person is not having taxes withheld, if the person is not under your control and supervision from it for a set period of time, you dictate his hours or her hours. If all of those things are you're answering no to, the person is an independent contractor. The content created by an independent contractor is not owned by the publisher unless there's a written agreement. And the written agreement must say that the content is being created pursuant to the work made for hire doctrine. It's one of the few areas in the law where words are magical. If those words don't exist in the written agreement, you don't own it. It has to be in the written agreement. And the reason for this is because of this case. CCNV is the abbreviation of the Community for Creative Nonviolence. A sculptor by the name of, I can't remember his first name, but Mr. Reed, and the executive director of the Community for Creative Nonviolence in Washington, D.C. It's at the time a very well-known grassroots advocacy organization for the homeless. Snyder, can't remember the first name for him either. Mr. Snyder commissioned Mr. Reed. They had a sit down in a coffee shop. Mr. Reed is a well-known sculptor. And Mr. Snyder said to Mr. Reed, you know, we could really use a sculpture that calls attention to the homelessness problem during the Christmas season. Can you do something? And Mr. Reed said, yeah, I think I could. So he created this bronze of a nativity scene, and I don't know that you can see it, but that is a steam vent in Washington, D.C., where homeless people actually do sleep on the steam vents during the winter. And the point was, this nativity scene in the 21st century is what happened in the first century. This was a very dramatic and potent sculpture that the Community for Creative Nonviolence then used to promote its causes, to create trinkets, to sell posters, to make money. And Mr. Reed said, excuse me, I did this out of the goodness of my heart, but now you're making money off this, I want to cut. Community for Creative Nonviolence said, wait a minute. Remember that sit down that we had in the coffee shop and we shook hands and you agreed that you would do this for us and we talked about what you were going to do and we came up with a plan for what you were going to do and we even supplied you with the material for the sculpture. We own it, not you. This went all the way up to the U.S. Supreme Court, and the U.S. Supreme Court said, tough luck, Community for Creative Nonviolence. You didn't have a written agreement. Because you didn't have a written agreement, Mr. Reed owns all rights in the sculpture and the right to exploit any commercial value. They eventually worked out a deal where only lawyers would come up with this. Mr. Reed owns the right to exploit the three-dimensional image. The parties would share revenue for sculptural copies, knickknacks, trinkets, reductions of the sculpture, and CCNV would own two-dimensional rights. So posters, pictures, representations in two-dimension, CCNV gets the revenue from. And that's the way the case ultimately resolved. But it is an important case for this ownership issue, and it is emblematic of the life that you all deal with, where you're dealing with content creators whom you have handshake agreements with. You don't even have handshakes. You've got emails. Well, there's an interesting question. Is an email in which you ask a freelancer to go cover the high school football game, and the freelancer sends you back an email saying, sure, I will. Is that a written agreement? It's writing. It's an agreement. There's an offer. There's an acceptance. In contract law, that's what we call a contract. Is that a sufficient writing to ensure that Freedom, the publisher, owns the content? No. You're all getting this is the professor. This is the trick. When I ask a question, it's not what you think it is. The answer is no, and the reason why is because it doesn't have the magic words. That's right. Doesn't say work made for hire. If you had this offer and acceptance, and in your offer you say, pursuant to our standard freelancer agreement, or can you do this for us under our freelancer contract? Or, better yet, here's an assignment for you that comes under the freelancer umbrella agreement that you signed last year. You get a standard form agreement, you get your freelancers to sign the form agreement, and it becomes the umbrella under which you make assignments. And when those assignments are made under the umbrella, you own the rights, so long as you're referencing the form agreement.